Good morning, everybody. It is an early one this morning for sure. So, we got a whole bunch of new documents that have been dropped. A lot of them are sealed, but there is some that we got our hands on here that give us a lot of information, really. Um, there's the state's opposition that we're going to go over with the motion, the defendant's motion to continue. And in that document, it's dropped some information about the witnesses that are going to be testifying for Bryan Kohberger. And we were under the assumption that, his family really didn't have a lot to do with him anymore. They were, you know, peeved off at what he apparently did, allegedly. So we got that. We've got an emergency hearing that has been called by the defense. There's been um, defense filings for new evidence. We're going to go over it. So let's start off, I guess, with this one here. I want to make sure you guys can see my mouse. Okay, you can. Okay, so we're going to go over this one here. Then we're going to go to the case summary, where I'm going to show you things that don't go into the actual public record. So you really have to go searching for some of this information. So let's go over this one. This one is basic. This is 22 pages. We're not going to read all 22 pages, you guys. I'm going to give you the rundown on it. And then we are going to go to the part where some of Bryan Kohberger's witnesses are listed. Who are they? What are they going to testify about, etc. So, state's opposition to defendant's motion to continue. Now, this has nothing to do with the emergency hearing. We're going to get into that one too. Okay, so it says, comes now the state of Idaho by and through a Latah County prosecuting attorney and submits the following opposition to the defendant's motion to continue the motion. It is time to try this case. The defendant was arrested in late December of 2022 and was indicted in May of 2023. He successfully moved to transfer venue to Ada County. In October 2024, this court entered its scheduling order, setting deadlines for pretrial motions and expert disclosure. The defendant has complied with those deadlines without moving for a continuance. So, what he is making sure the judge remembers is they were given all these deadlines back in October. That's like 9 months ago, right? And if they didn't feel that they could hit those deadlines, and that they couldn't be ready, they should have said something then. Also, at that hearing back in October, the judge told them, get more help if you need it because we're going through. He did extend it. He wanted the trial to go in June, and they extended it to August to give the defense more time. The defense said that they would be ready and willing and raring to go and all that crap, right? Initially, they wanted September, but the judge says, no, I'm going to split it. We're going in August. So the defense was on notice. This needed to happen. It also goes in this document. I may jump to that part before we jump into his witness list. Well, his partial witness list. It's not all of his witnesses. Um, but there's a part where, and they may even say it here, that they filed everything on time. So there's no reason for a continuance, right? Anyway, the defendant complied with those deadlines without moving for a continuance, including by disclosing 6 expert reports for the penalty phase, disclosing over 2,100 pages of purported mitigation materials, listing 55 penalty phase witnesses. 55 witnesses the defense is intending on calling for the penalty phase, and identifying 132 exhibits he may introduce during the penalty phase of trial. But now, after all discovery deadlines have passed and after the court conducted the pretrial conference, the defendant seeks a trial continuance of unspecified length. He bases his request on his claim that his mitigation investigation is incomplete. While the state is unable to see whether the defendant's ex parte filing to the court contains specifics, his motion does not. Defendant has not shared what new evidentiary materials he seeks to obtain or how additional investigation will actually produce them. Overall, the record before the court shows that the defendant's investigation has already plowed through the necessary ground. So if you're already filing your mitigation witnesses and stuff like that, um, and everything that they have filed so far, it's almost like, what is it that you need? We may see what that is in the next filings I show you. While defendant is fully entitled to due process, this court should exercise its broad discretion to deny the defendant's 11th hour motion, almost like an ambush, right? First, the defendant cannot show good cause or prejudice. Even under the heightened non-binding ABA standards he seeks to impose on the court, his counsel's resources and investigation to date have been adequate, even setting aside that the defense team still has more time to prepare its mitigation case. Moreover, Idaho's constitution also grants the victims the right to a timely disposition of the case. The court should give these victims' rights substantial weight in considering the motion. Finally, while publicity surrounding this trial is a challenge, the defendant has not shown and cannot show that continuing this trial will make things any easier. It's just as likely that delay will make it harder to seat a jury. For all these reasons, the court should deny the defendant's motion. So we're going to go through this procedural and factual background. It's not very long, and then we'll just skim through it and stop at certain points. Defendant was appointed as lead counsel in December of 2022. In March of 2023, a second attorney was appointed to represent him. Then in February of this year, a third attorney was appointed to the defense team. The first district public defender has also been participating in the defense. Good morning, Summer. Good morning, Kay Mitch. Kate Bell. In addition to his lawyers and their staff, defendant has 2 experienced investigators and a mitigation specialist working on his behalf. That's more than I have ever seen for a public defender case, right? It's like astronomical. If you remember back to Chad Daybell, he was facing the death penalty also. He didn't have half of this. Okay. In January 2024, the defendant moved for a change of venue from Latah County due to the publicity surrounding the case and the size of Latah County. His motion was granted and the case was moved to Ada County. On October 9th, 2024, this court issued the operative scheduling order that contained deadlines for motions, expert disclosures, and pretrial filings. More recently, at the pretrial motions hearing on April 9th, the court advised defense counsel to ask for more resources if the defense team needed assistance reviewing discovery. The state does not know if this occurred, right? So you can't claim foul when you do nothing to help yourself. You knew back in October, 9 months ago, that this was coming. You needed to be ready. You should have hired more people or asked for more help. And the judge is saying this, or the state is at least saying that they don't even know if that's occurred. Throughout the case, the defendant has been able to comply with the deadlines in the scheduling order. So if you're so far behind, you wouldn't be able to keep up with the scheduling order. Okay, pertinent to the instant motion, defendant has on January 23rd, 2025, made his guilt phase expert disclosures consisting of reports from 16 experts. Like I can't believe how many experts and lawyers and help that this team has, right? And like you look at the Chad Daybell case that was also in Idaho, there was three. There was um, the children, JJ and Tylee, his wife, right? And Charles, well, he wasn't charged with Charles, but still, there was three red drums there too. And he didn't have even a quarter of what this team has. Hang on. I'm about to sneeze. Hang on. Sorry, you guys. Allergies are through the roof. So 16 experts, including a psychologist who conducted a mental health examination of defendant, Dr. Orr, and a forensic psychiatrist who researched his life history, Dr. Ryan. This is one of the things that she says she needs more time because of about his life history. It's further in the document, but she specifies that that's what she needs more time for. Anyway, on March 3rd, but they gave the report on January 23rd, 2025. That's like 6 months ago. You know what I mean? Like, so what do you need more time for if you've already um, put in your expert disclosure regarding his life history? But you're saying in your motion that you need more time. We went over that motion. Go back and look at the last video where she says, well, we haven't been able to complete his life history and all this crap. But on January 23rd, she filed her disclosures from the expert, this forensic psychiatrist who researched it. On March 3rd, supplemental guilt phase expert disclosures with reports from two additional experts. And then as of June 2025, had disclosed in discovery over 2,500 photos and videos, over 3,500 pages of investigative materials, and many megabytes of electronic data related to the guilt phase. Right? So it seems to me like they've done a lot. They should be ready. On March 31st, made his penalty phase expert disclosures consisting of amended reports from Dr. Orr and Dr. Ryan, respectively, plus reports from four additional experts, three of whom are behavioral health neurology professionals. Wow. As of June 2025, had disclosed approximately 2,100 pages of purported mitigation materials and identified 55 defense witnesses and 132 defense exhibits for potential use during the penalty phase in this case. Defendant also opposed the state's motion for examination of defendant pursuant to Idaho Code 18207 and for an extension of time to complete the rebuttal penalty phase expert disclosures. At that time, defendant did not preview for the state or the court that he would seek a trial continuance. So, still, beginning of May, didn't say nothing about needing a continuance. The court denied the state's request for personality testing by its expert, in part because the pending trial date conflicted with the time that would be necessary to explore that issue. So, she opposed the prosecution being able to have him tested for personality testing by the prosecution expert, and part of that was like, "Look at your honor, there's no time for that. Our client doesn't have time. The prosecution doesn't have time to complete it because we're going to trial August 11th." So at this point, May 5th, she was ready and raring to go. Good morning, summer, summer, summer. So then they just go into the legal background. I'm going to scroll through this because a lot of you would like to maybe read through all this. So I will scroll it so you guys can watch it on the replay and pause it so you can watch through all this. Um, Defendant couches his motion in terms of his constitutional rights to due process, to effective assistance of counsel, to an individualized sentencing determination, and to a fair trial in light of intense media disclosure. But he has not demonstrated that these rights, which must be evaluated alongside the victim's rights and the overall administration of justice, will be violated if this case proceeds as currently scheduled. For the reasons discussed below, the court should deny the motion. Court should not exercise its discretion to deny the defendant's motion because he has not shown good cause for a continuance or that he will be prejudiced at trial. So, like I said, if you want to read through all these, I'm just going to read the headings. You can. Defendant's motion is untimely given the procedural posture of this case. Again, if you want to read through it, feel free to do that in the replay. You can pause it and read through this. If the defendant was having trouble meeting deadlines, finding experts, or pursuing red flags, he should have sought discovery extension or trial continuance long before now. So that's like one of their biggest objections with this is they've had plenty of time and knew where they were at their case for months, right? And I think that they're jumping on the bandwagon because of this Dateline episode, which is mentioned. But a lot of that stuff we already knew. Like we knew his car was caught on video, we just didn't see it, right? We seen a snippet of it. We didn't see the whole video that they had. So it's not like we didn't know that that existed. We knew. Um, the new thing was like, um, what was I just going to say? Oh, the photos of him and some of the things that people said about what he did at the party, but we knew that he was creepy at this pool party. We knew all about that. Even about the injuries that were afflicted, we knew that Kaylee suffered worse injuries than Maddie. We knew that Ethan had been hurt bad. We knew all that. We just didn't know to the extent, but we knew. I mean, come on. It doesn't take a rocket scientist to figure out, when they initially said, like, and we've known this for well over a year, um, that Ethan was hurt really bad. I'm going to say hurt instead of cut, but hurt really bad because of the red stuff that was dripping down the side of the building on the outside of the building. You knew that it had to be bad. So we knew that it was severe. So that really wasn't a big shocker. Um, we knew from disclosure that there wasn't just 12 or 13 times that he was within the 100 meters of the residence. It was 23. Excuse me. So we knew that there was a lot more times and we knew that there was video, but we haven't seen it. Like there is other videos that we haven't seen from different cameras that picked him up. We haven't seen them, but we know they're out there. So even if they would have been shown, we knew they existed. We knew they existed because of the probable cause affidavit and filings since his arrest, right? Since that probable cause came out. what else was in there, you guys? Let me know in the comments here. Other things that maybe we didn't know. Like I said, the photos, we didn't know that. We knew that he had taken that one photo with the thumbs up. We didn't know about the other ones with the hoodie on, with the black hat on, with the hoodie up. I think he was kind of, um, trying to look at himself to see what he actually looked like, maybe with that face covering and hat and hoodie on, whatever. What else was in there? Thank you, Summer. There was other things that were in there that, I mean, weren't a total shock to us. If there was, let me know in the comments here. If you guys can't see the comment box, hello, Dacia Do. If you can't see the comments where you can comment live, look under the video. It'll say open live chat box, and just click on that, and the live chat box will open up for you. Okay, so here is one that we are going to be looking into on the next document I'm going to show you. Defendant's purported need to conduct additional investigation is unsupported and does not establish prejudice, warning, a continuance. I believe that this is going to be, they want the drop from the railing going from the first floor to the second floor, and from the glove outside. I think that's what it is, that they want that tested. They may even be seeking for the sheath to be independently tested. But if you ask my opinion, I think that it is the DNA that could be in that tiny little speck that was on the railing and on a glove outside. Defendant bases his motion on a claim of insufficient resources and the need to conduct a more investigation prior to trial, but it is not demonstrated that he is being deprived of anything that he seeks. The defendant claims about the current state of the defense team's preparation are matters of speculation and not the type of demonstrable reliability needed to support a continuance based on the defendant's constitutional rights. Defendant's legal resources have been more than adequate, and I believe that they've had more than enough time with all these. We just went through how many people that they have on their team, all these investigators, 3 or 4 lawyers, plus their investigative team, their experts, plus all their staff, right? Uh, The defendant has 3 trial attorneys, including a lead attorney who has represented him from day one, 2 investigators. So 2 investigators, so there's 5. The assistance of at least 1 additional public defense attorney, that's 6. He is also engaged in outside mitigation specialists to assist in obtaining materials, so that's like 7. This record reflects his defense team has been working hard for the defendant, as explained below, and has met the professional standard for the defense of a penalty case. Hello, Vera Ray. So he's saying that this is unfounded. The defendant's attorney have had sufficient time to review discovery and have not established any discovery violations by the state. They have been able to identify over 1,000 exhibits and nearly 200 witnesses for trial. 200 witnesses they say. Indeed, the court has also recently admonished defendants' counsel to seek additional resources from the resource judge if they need more assistance to review discovery and to prepare for trial. Defendant has not claimed that he sought more resources and was denied. Neither the size of his legal team nor the need to continue review discovery form a valid basis for a continuance. Defendant's expert witness resources have been more than adequate. The defendant has been able to retain a large routine of experts, including 6 experts focused on mitigation for the penalty code. 5 of these experts are mental health professionals. Both a psychologist and a forensic psychiatrist have examined the defendant on multiple occasions, reviewed his social and medical history, and diagnosed him with autism, OCD, and ADHD. Collectively, these experts took a deep dive into the defendant's entire life, including by interviewing his family, teachers, coworkers, and even a psychologist who evaluated the defendant as a child. The extensive investigations by these experts contradict the defendant's claim that he needs more time to complete a social history investigation. That's one of the reasons that they were saying that they needed this continuance, that they need to do this social history investigation. It seems to me like they dive deep right back into his childhood, and they submitted those experts' reports already, right? In the cases he cites, counsel was ineffective for failing to explore mental health conditions, for failing to provide. So, in the cases that they cited to try and, back up their claim, the prosecution is saying in the cases that he cites, counsel was ineffective for failing to explore mental health conditions, for failing to provide mental health experts with sufficient background information. In contrast, here, the defendant's mental health experts have had access to a significant amount of people and materials and have created fulsome histories even through their own investigation. Defendants claim that his team needs to follow up on red flags is also unsubstantiated. In the reports, neither his psychologist nor his forensic psychiatrist indicated they could not render opinions based because of unexplored areas. Hang on. In fact, the forensic psychologist concluded that the defendants showed no signs of other serious psychotic disorders, and at a recent hearing, the defendant represented that he would not seek to introduce evidence on this unexplored topic, but now they are, right? Now they're saying they need more. Tellingly, the defendant did not seek an extension on the penalty phase expert disclosure deadline. So, in other words, because they didn't ask for an extension for this deadline on the penalty phase for this expert, and they've already submitted this expert's report, why are you asking for an extension on it? Right? So the defendants claim that more expert testimony is needed is speculative and does not identify what new information would be uncovered by further investigation. This is fatal to the defendant's motion. Defendant's counsel investigation into his life story has been more than adequate, and his reliance on the ABA guidelines is misplaced. There is no authority to support the defendant's desire for more time to conduct a scorch the earth life history investigation. Court recognizes that all cases, including death penalty cases, are constrained by limited time and resources. We have never held that counsel has a duty to uncover every aspect of the defendant's past and to present all evidence that might bolster a defendant's mitigation case. Rather, trial counsel's resources are limited and the strategic decision to emphasize certain aspects of the defendant's background at the expense of investigating others is both reasonable and wholly acceptable. Okay, so that's what they had said. Faced with this authority, defendant turns to straw man arguments and non-binding guidelines to conjure up alleged prejudice. First, he cites cases where death penalty sentences were overturned because lower courts failed to consider mitigation evidence. Now, I do feel like they've had more than enough with all these experts, especially on his mental health and everything else. Um, I don't see how this is going to fly. Okay, so we're going to scoot through this. Like I said, if you do want to slow it down and read it, you can do that in the replay. As a factual matter, even if the court looks at the ABA guidelines, the record reveals that the defendant's counsel has complied with them. Table 1 and Table 2 attach to this brief cross-reference the list of tasks defendant sets forth from the ABA guidelines with actual record in this case. Boop-a-doo. And we got it. I don't know if that was supposed to be sealed, but we have it. Defendant's ex parte filing should not cause the court to grant his motion. Defendant filed an ex parte, an additional document that purports to outline what new evidence he might seek and what strategy or tactics he might use to obtain the evidence. Now, the prosecution isn't privy to this. They don't know what this is because it was an ex parte, which means that they had a meeting probably in camera with the judge, just the defense and the judge, so they could explain and give their argument as to why they need this, what it's gonna provide, what they're looking for, how they're gonna get it, everything else, and the prosecution was not there for it, and they're not entitled to be there at an ex parte hearing. So they don't know what it was. But initially, the court expressed skepticism that the defendant's motion was properly filed ex parte and ordered defendant to provide a redacted copy of this filing to the state for it to address in this response. Defendant then objected to that order, and the state now understands that the court has decided not to require the disclosure of the ex parte filing. Now, I know a lot of people have been um, saying, "What is this? That the judge stayed one of his own orders." This is it. The judge ordered the defense to turn over a redacted copy of this document, and then the judge changed his mind and he stayed his own order. Staying means that it's been put on hold. So I was surprised actually when there's one lawyer that I do watch, and he was saying, "We don't know what this order is that they stayed." And you'll see that in the next document I show you, the filings, um, the case scheduling, which is different from where I get it's in the same area, but it's different from these filings here. I got more filings over there that aren't filed on the public side here. But anyway, um, they were kind of baffled as to what that order staying his order was. Well, this is it. I mean, it's in the document. So, um, so the court then has decided not to require disclosure of the ex parte filing. So he ordered it. Okay. Initially, the court expressed skepticism that the defendant's motion was properly filed ex parte and ordered the defendant to provide a redacted copy to this filing for the state to address in this response. Defendant then objected to that order, and the state now understands that the court has decided not to require. So he has to put a stay on that order, cancel that order. That's what the stay is on his own order. Okay, so I wanted to make sure that you guys heard that, seen that, because a lot of people are wondering, including some lawyers that have channels here on YouTube, are wondering, why is this stay? Why did the judge stay his own order? What order is he talking about? Here it is right here. So if you guys do watch those, you can go over and tell them you heard it here. This is where it is. The Idaho Constitution Victims' Rights Amendment is another basis to deny defendant's motion. While the defendant's reasons for a continuance are unpersuasive, there is another reason to deny his motion. The victims in this case, including the immediate family members of the homicide victims, have a right under the Idaho Constitution and Idaho Code to the timely disposition of this case. Given that it has been nearly 2.5 years since the defendant's arrest, the victims' rights and their desire for justice weigh in favor of proceeding to trial as scheduled. While the term timely disposition is not defined, it must mean that at some point a trial court can decide that the administration of justice outweighs the defendant's desire to continue to prepare his defense. That is one of the purposes of the Idaho Victims' Rights Amendment and is consistent with Idaho cases requiring a defendant to show actual prejudice in order to successfully challenge a decision to deny the motion to continue. In this motion, the defendant cites many cases where counsel failed to adequately prepare for trial or sentencing, but he cites no case where a court found that over 2 years was an inadequate amount of time to prepare, nor could he. He concedes that the Sixth Amendment only means that the defendant is entitled to a reasonable period of time before trial, which counsel might prepare the defense. While he appears to want unlimited time, defendant has already had a reasonable amount of time to prepare, demonstrated by the substantial quantity of evidence its attorneys have amassed. Against this backdrop, court can properly rely on the victim's constitutional rights as a basis to deny his motion. Give me 1 second here, you guys. Okay, sorry about that. That was Mama. Okay, despite intense publicity, the court should exercise its discretion to deny the defendant's motion and proceed to trial using its carefully planned jury selection process. There's no doubt that the publicity surrounding this case, including but not limited to a recent Dateline TV show containing non public evidence, poses challenges for the court and both parties. The state reaffirms it's committed to comply with the court's non dissemination order, to do everything in its power to prevent leaks, and to assist in determining which person or persons provided non-public information to Dateline. However, defendant's reliance on the Dateline episode to support his motion is misplaced for several reasons. First, and well, I'm going to go through these. We all know what this is. A lot of this has been out already. Good morning, Dawn. But if you want to read through all of this, we have talked about this already. You're going to have a hard time selecting a jury anyway, regardless of this Dateline episode. Um, it's a high profile case, and there's no changing that. None. Zero. So, like I said, I'm going to scroll through this so you guys can read it. Conclusion: the foregoing reasons the court should deny the defendant's motion to continue. So, now, a lot of people who covered this, and I know that there are other people that covered this, I noticed that once they seen the conclusion here and William Thompson's signature, they just gave up on the document. They stopped. They should have continued because below we've got tables. Defendant cited area of inquiry per the ABA guidelines. Okay, medical history. So the defendant, these are all the reasons the defendant has cited why they need extra time. And this is the state's response to that. Okay. So the state is giving out information here on people that will be testifying, right? Contained in an exhibit, in defendant's exhibits, and you're just going to see these are all defense exhibits. Okay. He says that his medical history is addressed in multiple expert reports of mental health professionals. And anything you see with a D in front of it, like D839, that's defense. The D means defense. It's a defense document. So, he says family members can testify about this topic. Any missing medical records have been available to the defendant, can be obtained prior to the penalty phase. Complete prenatal, pediatric, and adult health information. Again, he says it's contained in all these defense documents, and family members can testify about this topic. So, family members are going to be testifying, but wait, because they start giving initials. Exposure to harmful substances in urine and in the environment, no evidence this is resident. Oh my God, Willow, get it together. Relevant. Substance abuse history contained in the defendant's exhibits. Again, these are all defendant's exhibits. Anything with a D is a defendant's exhibit. And also, the family members can testify about this topic. Mental health history contained in the defendant's exhibits. Again. Family members and other identified witnesses. Okay, so here we go. He starts giving initials for other people who are going to be called as witnesses for Bryan Kohberger. Family members and other identified witnesses, including a former teacher with the initials AP, and evaluating a psychologist, ENC, can testify about this topic. Okay, so this is his mental health history. So, a former teacher with the initials AP and an evaluating psychologist with the initials EN and C can testify about this. History of maltreatment and neglect, no evidence. Trauma history records related to childhood car accident contained in Exhibits D, defenses exhibits, defenses exhibits, and defenses exhibits, addressed in multiple expert reports of mental health professionals, and the family members can also testify about this. Educational history. Um, Look at this. Contained in the defendant's exhibits, these are all defendant's exhibits, defendant's discovery, addressed in multiple expert reports of mental health professionals, the defendant's exhibits here, family members, other identified witnesses, including former teachers. So, family members, and there is former teachers, MB, JC, CH, DM, AP, KR, DW, and former classmates. So these are family members and other identified witnesses, including teachers. So these are other family members, maybe, and teachers, former classmates, MD, AH, AM, CM, EP can testify about this topic. Thank you, Vera. Any missing educational records have been available to the defendant and can be obtained prior to penalty phase. Employment and training history. Defendant has limited employment. Okay. Family members and other identified witnesses, including professor he worked for, JS, and former co-workers, AI et al., maybe, can testify about this topic. Any missing records have been available to the defendant and can be obtained prior to penalty phase. Military experience, thank God he was never in our military or yours, not applicable. Multi generational family history, genetic disorders, and vulnerabilities, as well as multi generational patterns of behavior. Penalty phase. That is if he is found guilty, they go to a penalty phase. They have another like mini trial within a trial to see if he's going to get the death penalty or not. That is what the penalty phase is. Uh, so all of this here is contained in the defendant's exhibits. Okay, look at all these and the defendant's discovery that they've handed over. Addressed in multiple expert reports of mental health professionals, and family members can also put their 2 cents in. Prior adult and juvenile correctional experience, no, not applicable. Religious, gender, sexual orientation, ethnic, racial, cultural, and community influences. Family members and other identified witnesses, including fellow congregants, EM and JR, acquaintances, AF, and friends, BA and DF, and neighbors, ANA, AUA, FA, and GN, can testify about this topic. At least some religious history contained a discovery. So that's going to be the discovery there. Socioeconomic, historical, and political factors contained in the defendant's exhibits, his own exhibits, addressed in multiple expert reports of mental health professionals, family members, and other identified witnesses, including fellow congregants, EMJR, acquaintances, AF, friends, BA and DF, and neighbors, AA, FA, and GN, can testify about this topic. So he's got neighbors too, right? Now, are these the neighbors from um, Pennsylvania? neighbors from Washington, right? Because remember, he tried to make friends with people in his building and, you know, somebody that lived across the hall, I think, from him and stuff like that. I wonder if one of these neighbors, I don't think they will call the girl that he installed the security cameras for because I think the prosecution's going to call her because she was creeped out. The client's witnesses defendant wants available per the ABA guidelines. The client's family extended 3 generations back and those familiar with the client. All living family members are subject to the subpoena power. Many have spoken to the defendant's expert witnesses and are on the defendant's witness list. CE, so AK, this is his dad. Um, I don't know. Hang on, let me Google this. Bryan Kohberger family mem- members' names. Okay, so there's Michael Kohberger, who's going to be this one, I think. M.I. Kohberger. Mary Ann Kohberger. So I think this is Mary Ann Kohberger. Oh, his parents, Mary Ann Kohberger, is his mother. So Mary Kohberger, this one here is his mother. This one here is his father. AK is going to be Amanda, and ME is going to be Melissa. I don't know who RK and SK, maybe his grandparents. What do you guys think? What do you guys think? Um, so all these people, whoever CE is, I don't know who CE is, but we know that this is his sister Amanda, this is his sister Melissa, this is his mother Mary, this is his dad Mike. I don't know who RK, maybe his grandparents, RK and SK, and I don't know who CE is going to be. Anyway, the friends, teachers, classmates, coworkers, employers, and those who have served in the military with the client. What do you mean? He was never in the military. As well as others who are familiar with the client's early and current developmental development and functioning, medical history, environmental history, mental health history, educational history, employment and training history, military experience, and like I don't know who put this in here, but he has no military history. And they do it again here. And racial, and cultural experiences influence upon the client or his client's family. Many individuals falling in these categories have spoken to the defendant's expert witnesses and are on the defendant's witness list. ALA, BA, MB, AD, CH, AH, AM. So this is probably the wife of whoever this is, because this is AM. And you see this a lot with when women get married, they keep their birth name hyphenated and use their last name. So AH hyphenated M. So this is probably the wife of this one. CM, DM, EM. So these are probably all family members. Um, EPJR and KR, they're probably family members. These two are probably family members. Uh, JSDW. Okay, social service and treatment providers to the client and the client's family members, including doctors, nurses, other medical staff, social workers, and housing or welfare officials. At least one psychologist who evaluated the defendant as a child, ooh, has spoken to the defense expert witness and is on the defendant's witness list. EN hyphenated C. Okay. Defendant's medical history also reveals other providers who can be called as witnesses, though it appears defendant has chosen not to do so. So you can't claim foul and then put your foot in your mouth, right? So they decide they're not calling them. Why? I don't know. Are they going to say something that's not going to be helpful for the defense? Witnesses familiar with the client's prior juvenile and criminal justice and correctional experiences not applicable. Family members can testify about the defendant's behavior generally. So some of these family members are coming in, and they've listed the sisters and the parents. So former and current neighbors, former and current neighbors of the client. Defendant's witness list contains neighbors ANA and AU. So is this could be like Austin A? AU? Like, what other name starts with AU for a male? Or this could be Andrew and this could be Autumn? I don't know. And FA, so maybe one of their adult children, but this seems to be all family members. And GN, do you guys remember? Let me know in the chat. Do you guys remember that guy that lived in the same building that Brian tried to friend? What was his name? Do you remember? Because there's initials GN with current and former neighbors, right? Family members are best positioned to testify about these topics. Okay. Okay, so this and the availability of employment and prevalence of violence. Okay, witnesses who can testify about the applicable alternative to a death sentence and or the conditions under which the alternative sentence would be served. The defendant has retained and disclosed an expert witness, JA, to testify on this topic. Witnesses who can testify about the adverse impact of the client's execution on the client's family and loved ones. This irks me because you didn't think about all the huge amount of people that were affected by what you allegedly did to four families, not just one, right? The adverse impact of the client's execution on the client's family, how they're going to feel about it, how are their loved ones going to feel about him being, you know, executed if he's found guilty. What? Did you guys care? Did he care if he is found guilty? Did you care about the impact of four families and their loved ones when you brutally took their life, allegedly? I've got no sympathy. Sorry. I veritably believe in an eye for an eye. I'm sorry, but I do. Eye for an eye. If you're going to give it, you better be prepared to get it. If you're willing to take somebody's life, be willing to have yours taken too. So that is the other things that are like we've got some information here, and it looks like all his family's going to test it. The defense has them on their witness list, as well as friends. I don't see a lot of different names here, so I don't know. Like this is just a little peeksy at some of the people on his witness list, because the prosecution has said that there's like 50. 50. Okay, so let's go over here. We're going to go to the case summary. Um, case flags, no contact orders outstanding. Okay, so this is interesting because this is huge, you guys. This is 98 pages. You can see it up here. But we're going to scroll because this is what we're interested in. We're going to go back. Let me just, I want to go back to June here. Where does it start? Boom, boom, boom. this is a whole different part of this. Okay, let me get down here. Okay, so it starts here. So we know, let me blow this up so you guys can see. We know that the defense filed offer of proof re alternate perpetrators and the defendant's evidence in support of officer of proof re alternate perpetrator. You guys with me? Either my chat's not working or you guys are really quiet. Well, thank you, Vera. These have been out for a couple days, some of these, but there were some that were just released. So, um, and this is what they had the ex parte about. Okay. So then another motion was filed. We seen that one. That's the one that we just went over. Um, this to seal the state's objection to the defendant's offer of proof re alternate perpetrators. Oh no, this is the one we just Dacia Du says just listening. So there was a motion to seal the state's objection to the defendant's offer of proof for alternate perpetrators and defendant's evidence in support of offer of proof alternate perpetrator. Now here is a new one: a sealed motion for independent analysis of evidence. So on the 6th, we can't see this because it's sealed, so I can't see exactly when it was filed, but it usually goes into the record that day or the next day. So I'm saying around June 4th, 5th, maybe. Let me see my calendar. 4th, 5th, maybe. And it went into the record on the 6th, up onto here anyway on the 6th. I don't know. Anyway, um, a lot of these were just released within the last 4 or 5 days. Um, there's a sealed motion for independent analysis of evidence. And we know from prior hearings that we have watched that what is the one thing Anne has been pushing? Why wasn't the drop on the railing going from the first to the second floor and the glove prosecution told the judge, like, we would have had to, we already had evidence filed for the case in CODIS or whatever it was, for the knife sheath, right? And if they were to enter this somehow, would bump that out and they would lose it, maybe, I don't know. So they just didn't. They didn't feel that it was relevant. And apparently, from what I have heard, is it was a speck of red stuff on that railing. It wasn't like it was a handprint or a fingerprint or anything like that. Um, now, that railing going up from the first floor to the second floor in the 1122 King Road home, don't forget there's a half wall there. And Bryan Kohberger would have had to pass by that half wall to go through the living room, past Dylan Mortenson's room, and out through the kitchen or upstairs to the third floor, right? Um, could something have, flung in some of their, I don't know. It's somehow could a speck of the red stuff have gotten over that railing, maybe? It may not. You gotta be careful what you wish for, right? The defense is hoping that it is red stuff from somebody else, so it would um, back their theory of either two perpetrators or an alternative perpetrator, right? Because they are really pushing for one perpetrator couldn't have done this by themselves. There had to have been two, and they're really pushing for that. And I feel that if there was a second person involved, he would have come out with it by now. You know what I mean? So it's kind of like shooting yourself in the foot. Hello, Annie, and welcome. Good morning. And also, Juice is just listening. Okay, so And then there was a motion to seal stipulation in order for admission of additional exhibits at trial. Okay? This has been denied. We don't have documents on it over on the document section that we can see, but we know by the case summary that it's been denied. We'll see it coming up. Motion, sealed stipulated motion to the admission of additional exhibits as evidence at trial. So this is stipulated. So both sides agree that these additional exhibits should be admissible at trial. So what I am understanding by this is that they weren't filed on time, and both sides have agreed that these exhibits should be put into evidence and used at trial. Okay? But we will see further down that the judge denies it. Sealed motion to seal defendant's motion and order for emergency order. What is this? There is a motion for an emergency order. What could this possibly be? I want to know what you guys think in the chat. What do you think this could be? A motion for an emergency order. What do you guys think? I'm watching the chat. Sealed motion for emergency order. Okay, so the motion is sealed and the order for an emergency order. So the judge did order an emergency order because here is the order. And they have sealed not only this, right, which is listed here, sealed the motion to seal defendant's motion and order for emergency order. The sealed state's response, defendant's motion for independent analysis of evidence. So, with this statement here, I am feeling more along the lines as they want an independent analyst of the DNA on the sheath because they're not saying potential evidence, they're saying independent analysts of evidence. So that's something that's been filed already as evidence that's going to be used, right? Oh, they've been doing that for a while. And I mean, I get it, Dacia do. She has got to do everything in her power to try and get things thrown out. We've seen that. She's I mean, I've never seen a lawyer go in my 30 years of working with some of the most high profile lawyers. I have never seen it go to the extent that she's gone to. So you can't say ineffective counsel. I'm telling you that. Because she started bringing up 1800s law and everything else, and that it's still in the books and it should be followed, and all the precedents that have been set between 1800s and now should be discarded, and we should be going by the 1800 law that our founding fathers set. Like, I mean, she went balls to the walls. That is a famous saying. That's why I said it. Um, and she's throwing everything at the wall to see what will stick. She's doing her due diligence, and I get it. But what irritates me is to the extent. You don't have to file a 300-page document to get your point across. You know what I mean? It bogs down court time, and if you had spent more time working on this case than writing a 300-page motion, you would be on track. You know what I mean? You can't contribute to putting yourself behind an 8 ball and then claim foul. If you've contributed to being behind, then that's on you, right? So I believe with this is she's trying to get everything, and even with this trying to get a continuance, you know what she's going to argue? Well, Your Honor, then the only thing we can ask for, if you're not willing to give us a continuance, is take the death penalty off the table, because then we don't have to go through the death penalty phase and prepare for all that, which they've already done, mind you, because they've already filed their mitigation materials and experts and everything else. The only thing we can see to free up time for us is to remove the death penalty. And if the death penalty is removed, then we can focus all our attention on the trial and the guilt phase, right? So I don't know. She's bouncing all over the place and what she's doing. And I think we're going to hear this. I am going to be covering this next week on the 18th when it goes. We're going to have a hearing on the 18th of June. I will be covering it. We are only going to be allowed. You'll see it here in the document in a minute. Um, she is going to try and push a narrative. And I believe that she contradicts herself a lot. And I think it's going to come back and bite her in her butt. Right. And this taking, the judge has already thrown that at her when she complained about this back at the last, in the April hearing. He said that maybe you shouldn't have taken on another death penalty case, right? And I brought that out like almost a year ago, you guys. I said, like, she has taken on another death penalty case. Like, you can't even keep up with the case that you're doing and get through things effectively, and you've taken on another case. That's on her. That's on her. Okay. So I do believe that this is probably the sheath that, at this late at the 11th hour, like the prosecution said, almost like an ambush here. Now we have decided we want to have an independent analyst of evidence. She has said that she had found at the last hearing, she said that they came across some red flags. And I think that they're going to try and provision this into their alternate perpetrator. They're going to try and combine it all. Look at this is stuff that the prosecution didn't investigate. We think this person could have done it. I wouldn't be surprised if she tries to say it was Kaylee's boyfriend or somebody that from the party that Xana and Ethan were at over at that Sigma Chi, whatever that Bobo, whatever. So who knows? But she's had that for a long time. You can't do this at the 11th hour, especially once you have filed all your expert disclosures, right? Evidence takes a long time to get through the system, to get tested, to get results back, to be able to argue those results, to have experts look at it. You know what I mean? This is just another way, I think, for her to try and delay the trial. I don't know if the judge is going to buy it. I hope not. The same as this um, alternate perpetrator. This is sealing the state's objection to the defendant's offer of proof, alternate perpetrators, and the defendant's evidence. So they're thinking they have evidence in support of offer of proof regarding an alternate perpetrator. So they feel that they have found something, just God's will, all of a sudden, once the pretrial conference and everything's set to go, you filed all your expert reports and everything else and your witness lists and everything's been filed. Oops, all of a sudden, guess what? We found evidence in support of an alternate perpetrator. And if you don't let us do this independent analysis of this new evidence, then you are taking away Bryan Kohberger's right to a fair trial. This is another attempt, I believe, to have this trial put out again. And it's like, how many times has she done this now? She didn't want the trial this year. Don't forget, she wanted the trial put off until 2026, right? And the judge says, "Oh, hell no. We're doing this year in 2025. We are doing it." The prosecution wanted June. They wanted to keep that June date. The defense wanted September. So the judge said August. We're going in August. Do you think you can be ready by then? Yep, 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 yep. Right? Then we see the sealed order granting the defense expert analyst of evidence. So, for caution, hang on a sec, you guys. Yeah, I can do it. Yeah, later. Okay, thank you. Okay, so this is a sealed order granting the defense expert analyst of evidence. So the judge granted the defendant's motion for an independent analyst of this evidence. What evidence is it? It's either the sheath, because it says analyst of evidence, but it could also be that drop of the red stuff on the railing going from the first, second floor, or the glove outside. We don't know because it's all sealed. Sealing the defendant's motion and order for independent analysts. So it's sealed again here. Order, sealed order conditionally denying admission of additional exhibits of evidence at trial. Okay, so do you remember up here I said we will get to it, where right here, if you can see my, oh, you can't. Okay, I got to highlight it. Where both the prosecution and the defense, I said, remember this because we're going to talk about it later on. Now, when you just go to look up like things that have been filed like this, like all these filings, like that we see here, this is another section where you find out even more, right? It's not in that same section. Anyway, they both stipulated, the defense and the prosecution agreed to the admission of these additional exhibits as evidence at trial. The judge ain't having no part of it. Where did it go? Where did it go? Okay, so here is his order. Now he put a conditional order out, which means for now he is conditionally denying admission of additional exhibits as evidence at trial. What I am thinking, and that's why I'm saying this expert analyst of evidence, that's why I am leaning towards it could be the glove and the drop on the hand railing, because there's a conditional order denying admission. And I think that that's going to stay in place, that it's not going to be entered as evidence right now until the analytics come back on what or who is, if they can even find out, who is connected to that DNA on the rail or the glove. That's what I'm feeling. Because why else would he order conditionally or denying admission? So there's conditions attached to it. He's denying it with conditions. So unless they can prove that it connects to their alleged alternate perpetrator, it ain't coming in, right? Sealing stipulation in order for admission of the exhibits, that's all up here. Order sealing defendant's motion and order. So the order sealing the defendant's motion and order for emergency order. Here, this is what everybody, including a lawyer, you guys, that has a channel here, said, what is this? What is this? They feel like that is the emergency order. It's not. I showed you what it was, what that was regarding. Go on back and check what we just went over. I go through that, what this is. This is the judge when he ordered the defense to turn over mental health records redacted to the prosecution. and he ordered that, and then he stayed that order. So that's what that is regarding. And there's the order sealing his own order that he made. Judges do not like to do this. They don't like to stay or seal, not seal, but stay their own orders, which means they're admitting they probably made a mistake. Judges do not like to do this. So, I mean, they're human. We all make mistakes, you guys. Motion to seal defendant's second amended phase two mitigation witness list. So they want to add more people or amend it, maybe take people out, maybe add. Seal defendant's second amended phase two mitigation list. We won't see any of this. To seal defendant's motion and order for independent analysis of evidence. We've seen that up top. Sealing defendant's second amended phase two mitigation list. We've seen that. So this is them asking for it and the judge doing it. Subject document motion to redact or seal newly filed record. This was done yesterday. Motion for access and fair investigation. I believe now, I don't know 100%, but I'm going to give you my opinion. I know things work different in the States than they do here. Um, Motion to redact or seal newly filed record. Objection to release of privileged and confidential work product. I believe that this is coming from the defense. I don't know, but the motion to redact or seal newly filed record. It's a subject document. Subject document. Motion to redact or seal newly filed work product. Objection to release of privileged and confidential work product. Um, I feel this is coming from the defense, and they want. I think they're saying that they're not getting all the information regarding this newly found evidence, which I think is all regarding this independent analysis of evidence. I think that there's something there that they want. They want from the prosecution. The prosecution is saying you're not getting it. It's privilege. It's work product. You're not getting it. That's what I think that this is. Okay, so moving on. This just come out. This is the first time I'm seeing it. So you are seeing these two things just as I am right now. These were just filed. And because I'm on the East Coast and they're on the West Coast, they're like 3 hours behind me. Sometimes I don't see this till the next morning because these aren't filed sometimes until 5, 6 o'clock Idaho time, which is like 9 o'clock my time. I'm usually in bed by then, snoring away. I don't snore, but anyway. Okay, so June 18th, we are going to be covering this. That is next Wednesday. We are going to be covering this 12:30 Idaho time, so it will be 2:30 my time. Um, we are going to be able to see the motion to continue. It's not sealed. So hopefully they do that one first. And then they will close the courtroom, throw everybody out, because then there is going to be he's going to hear the motion on alternate perpetrators, and that is sealed. So hopefully we get. Uh, you guys don't understand. I have changed my whole vacation time, downtime, schedule. I've cleared things to cover this Bryan Kohberger case starting in August. If this doesn't go ahead now, I'm going to be pissed. Okay? Because there were some things that I wanted to do in August that I have rearranged and changed so I could be here to cover this for you guys. So Jury selection is supposed to start August 4th, and the actual jury trial is starting on the 11th. There's also another hearing. This is canceled. I don't know why they canceled that one, but it's been moved to July 30th. There will be another hearing with Stephen Hippler just before jury selection begins. So we only have two more hearings, you guys, before the trial starts. We have the one on June 18th, and we have the other one July 30th. And this one, we are only going to be able to hear the motion to continue. And hopefully, the judge has already made his decision on this, or has a good idea which way he's going to go. I hope he doesn't take it under advisement. And then we got to wait, because the sooner I know if this is going to be continued, I can rearrange plans again, right? So, sorry for the cough, everybody. So, that's what I've got for you guys. Um, we will not be seeing this alternate perpetrator that is sealed. We will not be seeing that. But this to me is the most important. And it's not sealed, so we'll be able to see that. And I will be covering that. It should be, I'll probably go live at around 2 o'clock Eastern. Okay, so with that being said, you guys, I'm going to end this like I always do. Thank you, you guys, for being here. Thank you, mods, for being in here and keeping things running smoothly. I appreciate each and every one of you. And with that being said, I'm going to end it like I always do. Please take care of yourselves. Please stay safe. Always be aware of your surroundings. Be careful who you trust. I love you guys to the moon and back, and I will see you guys again soon. Bye bye for now.